Okay, we're now live. Good evening and welcome to the third session of the NUJS Online Lecture Series, hosted by the Student Juridical Association 2019 to 20, in collaboration with Live Law as our media partner. With us today, we actually have two NUJS alumni. Mr. Suhrith Parthasarathy will be the guest speaker, talking on digital rights and the Aarogya Setu app, a discussion that has become extremely pertinent lately, especially in context of recent news reports that talk about how it might become compulsory for interstate travel, opening bank accounts, and much more. There's going to be a 30-minute question and answer session at the end of the lecture, so do let us know your questions in the comment section to the right. The session will be moderated by Professor Ankit, currently an assistant professor at NUJS and who is also an alumnus of NUJS. Professor Taraftar has immense experience in the field of digital privacy, currently teaching a course on the same, and also having been published in several prestigious newspapers and journals regarding his views on it. We'd like to thank both guests for agreeing to do this, and without further ado, I'd like to hand over the mic to Professor Taraftar to introduce our guest speaker.
Thank you, Ayushi, and a very warm welcome to all our listeners today. As she has already pointed out, the topic for today's discussion is the Aarogya Setu app, and we'll get to that in a bit, as well as the introduction of our guest speaker. But the reason this discussion becomes relevant in the current context is because we see across the world that a number of governments are taking steps, emergency powers are being assumed. Viktor Orban in Hungary has almost proclaimed himself a dictator. There are wide surveillance measures being introduced across the world by different governments, not necessarily all totalitarian regimes as well. And in this context, the Aarogya Setu app that the government of India has, the Ministry of Electronics and Information Technology has introduced, has itself sort of created some sorts of controversies, which we will, of course, talk about during the course of the session. But what makes this entire project very interesting is that the app came in followed shortly by a protocol. This was not a law. A protocol was introduced to sort of guide the user of the app, as well as in the data principle, as well as those who will be using this data or transferring this data. So this entire module was created through a protocol which was written by an expert committee, which led to an entire Twitter war, as those who are aware would know. To speak to us about this and many other issues related, we have with us Mr. Suhrith Parthasarathy. Mr. Parthasarathy is an advocate practicing at the Madras High Court. He's a graduate of NUJS and has over 10 years of experience at the bar. He possesses a graduate degree in journalism from the Columbia University of New York. His litigation practice is primarily focused on income tax and public law work, and is, of course, Suhrith is also a regular contributor to Hindu, among other leading newspapers. And just as a bit of a personal touch to this, Suhrith, of course, as Ayushi has mentioned, is an alumnus of this institution, and when he came down to the university a couple of years back for the alumni meet, some of us couldn't even get a chance to say hi because he was thronged by so many of his fans among the student community. And that's very well deserved, of course, considering that even full-time academics are nowadays having trouble managing to come up with the volume and the quality of his written work. Welcome, Suhrith, and over to you.
Thanks very much, Agnito. Good evening to all of you. I think Agnito has been very too kind to me, and but in any event, I'm delighted to be speaking to all of you this evening about digital rights and privacy in the context of recent developments, in particular the creation of the Aarogya Setu application. What I'll do is I'll speak for roughly about 30 minutes, and then we can open it up for questions. I'm assuming that all of you are from different batches. Perhaps some of you are also not law students. So I wouldn't assume that each of you has already studied constitutional law. So I'll try and keep the broad domain of the discussion simple, while at the same time not compromising on the technicalities to the extent possible. Now, I suppose what we don't really need anymore is a reiteration of why privacy might be important. I think we can start with a general understanding that privacy is a value of substantial importance, that it has both an intrinsic value in that our bodily integrity, our dignity is deeply intertwined with privacy. Now, it also has an instrumental value. What do I mean by it having an instrumental value? What I mean by it having an instrumental value is that privacy also serves to protect other rights, such as the rights, for example, to free expression, freedom of movement, freedom of religion, and so forth. And in having this instrumental value, it also tends to impinge on democracy itself. In many ways, the protection of privacy bears a direct nexus to how a democracy might function. Because if we don't have privacy, then what we essentially would be living in is a surveillance state. And when we live in a surveillance state, then you can quite imagine that it would be impossible to conceive of democratic governance in a state such as that. Now, we all also, I'm sure, even the students amongst you who belong to the first year, know the commonly understood story of how privacy came to be regarded as a fundamental right. The Constitution itself doesn't explicitly spell out the right to privacy. It doesn't say in Part 3 anywhere that all citizens or all persons are guaranteed a right to privacy. So it's a right that has been conceived through textual interpretation, through interpretation of the language of the Constitution, its history, and through a conjoint reading of the various fundamental rights that are guaranteed in Part 3. As I said, I think we all know the story of how privacy came to be regarded as a fundamental right, the story that began from MP Sharma's case, to Kharak Singh, to Gobind, to Rajagopal, to PUCL, and ultimately to the 9-judge bench judgment in Puttaswamy, which was delivered on August 24, 2017. Now, it is through an interpretation of the various fundamental rights that are guaranteed explicitly by the Constitution that the Supreme Court, in the 9-judge bench decision, unanimously declared that every person in India has a fundamental right to privacy. But they didn't stop at making just that declaration or just answering the question that was put to them in the affirmative. They also went on to hold, and there's of course a plurality of opinions here. We don't need to get bogged down about what each judge might have said, but a majority of them clearly also recognize that privacy has various different aspects. And at least two strands of what privacy stands for we might want to keep in mind. One is the commonly understood notion of privacy serving in a capacity of a right to be left alone, which was of course conceived originally in the famous Harvard Law Review article that was authored by Warren and Brandis. The other, and this is critical for our discussion today, is privacy in an informational sense. That is, in the sense of preventing the state or other private actors from illegitimately disseminating private information. Now, this is why a number of countries and a number of jurisdictions across the world have data protection laws that explicitly prohibit the state from misusing personal information. And a lot of different things go into these data protection laws in terms of what kind of private information the state can access, in terms of how much private information the state can retain, in terms of how it goes about disseminating this private information. All of this is ordinarily packed into a data protection law. But the Supreme Court, nonetheless, in Puttaswamy's case, through a joint reading, in fact, of the two Puttaswamy judgments, the first judgment of the 9-judge bench, which recognized a fundamental right to privacy, and the second judgment of a 5-judge bench, which ruled on the constitutionality of the Aadhaar Act. If we look at these two judgments jointly, there are a set of principles that we can glean. And these principles would tell us that the Constitution as it stands today expressly recognizes a right to informational self-determination or a right to informational privacy. But let's take a quick look at these broad legal principles that are at stake now through this inauguration of this Aarogya Setu app and through the function creep that is likely to emanate out of it. We've already seen that the Aarogya Setu app has been made mandatory for a number of different people. In Noida, for example, there's an order that makes it mandatory for any person who owns a smartphone. So we've seen how it's sort of creeping on us and moving from what was possibly, I wouldn't even say what was conceived as voluntary, but what was at least put out as voluntary being turned into a mandatory mechanism. So what are the principles that are at stake here when we look at this app, before we come to the app itself? The broad legal principles, if we were to look at the two judgments in the Puttaswamy cases, are first, as I said, we now know after the 9-judge bench decision that the right to privacy is a fundamental right, that its contours do not occupy any separate silos, but there are different aspects of it that can be found in various different fundamental rights. And I mean, we don't need to again get bogged down in terms of trying to give an exact or a precise definition to what privacy might mean. As long as we broadly know what kinds of infractions or restrictions that are put forward by the state would violate the right, that would suffice. Now, privacy might be recognized in some aspects in Article 14, in different aspects in Article 15, in some other aspects in various clauses of Article 19, and of course in Article 21 and Article 25 as well. So what we have today is a scenario where it is beyond the pale of doubt that the Constitution guarantees a fundamental right to privacy. But we also, of course, know that no fundamental right is absolute, that the state can, in certain circumstances, legitimately curtail a fundamental right by bringing in restrictions through law. Now, almost right from the outset, the Supreme Court has been clear that a restriction, for example, of the fundamental right to life and personal liberty can only be made by a state action that is undergirded by legislation. So when Article 21, for example, when Article 21, for example, states that no person shall be denied the right to life and personal liberty except through procedure established by law, that law, according to the Supreme Court, has to necessarily be a law that is made by a valid legislature. That is, either by Parliament exercising its powers under Article 245, read with the various subjects that are enlisted in List 1 and 3, or by a state legislature on those subjects that are enlisted in Lists 2 and 3. Now, so just to sort of recap quickly, what we now know, therefore, is that there exists a fundamental right to privacy, and that this right can only be limited by a law that is made by a valid legislature. We also know from the Aadhaar judgment that the collection, storage, and usage of data in a fashion that would help the state profile an individual is illegitimate and unconstitutional. That is, if the state collects a set of data from people and it is thereafter in a position, by putting all of the data that it collects together and creating a profile of an individual, then that is something that the Constitution, according to the Supreme Court, explicitly proscribes. Now, of course, in the Aadhaar judgment, the court held that this Aadhaar Act did not in fact lead to a mechanism, according to it, where the information that it collated, the biometric data that it collected, could potentially lead to a profiling of an individual. Now, of course, I believe that the court came to the wrong conclusion, but at least one takeaway that we have from the judgment is that a creation of a profile, or the ability of the state to create a profile through the data that it collects, stores, and uses, would in and of itself amount to an unconstitutional action. Now, what I mean by profiling here, of course, is the extrapolation of information about a person and the ability of the state to construct a detailed image of a person through the information that it has disseminated or collected from various individuals. Now, there are also a few integral principles of any data protection law that we must keep in mind. And even though we don't yet have a data protection law, the Supreme Court in the Aadhaar judgment explicitly recognizes these principles as foundational in many ways, and also recognizes that a violation of these principles would constitute an illegitimate restriction on the fundamental right to privacy. Now, what are these integral principles that any data collection must conform to? Now, of course, you have the European Union GDPR regulations, which lay out a set of 6 principles. But broadly, without getting into those 6 principles, we can talk at least of the principles of data minimization, purpose limitation, and data retention. And I'll come to sort of what each of these means shortly. And when we talk about these principles and where they're important, we don't need to merely envisage a situation where an application is built, for example, by the state in the nature of, say, the Aarogya Setu App. It might be data collection for any purpose. Now, for example, the Income Tax Act requires various individuals, companies, etc., and various bodies to file all kinds of information with the income tax authorities. So if I'm filing a return of income, I would disclose, for example, details of where I got money from, or where, who are the people who might have paid professional fees to me, for example. And all of this information I would submit along with my return to the income tax authorities. Now, even that data which is collected by the income tax authorities has to conform to these broad principles, in the sense that it would, because on the face of it, the moment the state coerces you to disclosing any information to it, then that would amount to a prima facie violation of your right to privacy. And thereafter, therefore, that collection of that information has to be legitimate and has to be tailored according to these various data protection guidelines. And for example, Justice Nariman's judgment in the original Puttaswamy case, in the 9-judge bench judgment, draws this analogy with the Income Tax Act. He speaks about how the very nature of submitting information to the income tax authorities is, on the face of it, a restriction of a person's right to privacy, because ultimately a person who is filing a return is disclosing vast swaths of personal and private information to the government. But that doesn't mean that the Income Tax Act is in and of itself unconstitutional, so long as the data that it collects for these purposes, that is for the purposes of levying an income tax, is proportionate. And this is something that we'll come to shortly. So what do we then mean by data minimization, purpose limitation, and limited data retention? Now, by purpose limitation, what is commonly meant is that the state or any body that is collecting personal data has to collect it for a specific purpose. That purpose has to be clearly spelled out. Now, you can't have the state simply saying that it will collect data and retain that data for as long as it deems necessary, without actually telling us why, in fact, it is collecting this data. So that is the first and most critical principle that we have to keep in mind, which is the principle of purpose limitation. The second principle is a principle of data minimization. That is, that the data that the state collects has to be adequate, has to be limited to what is necessary, and has to be relevant. That is, there has to be a rational link that connects the purpose for which the state is collecting the data and the data that it is in fact demanding. So, for example, to once again take the example of an income tax scrutiny, when the income tax authorities commends a person to file an income tax return, it can only call for those kinds of information that are relevant for the purposes of scrutinizing your income. So, for example, it may not be necessary for the income tax authorities to know what diseases that you might be plagued with, for example, or that what kinds of illnesses that you might have had in the course of the last year. It can't, for example, require you to enlist every visit to the doctor that you might have made over the course of the last financial year. These are informations which are absolutely irrelevant and extraneous to the purpose for which the state is collecting information, which is to assess your income. The third principle, and this is really, I took income tax as an example. It would be relevant for any other kinds of state action. For example, for a property tax assessment, or if you're going to register your property, there might be certain kinds of information. Let's say you want to sell your property to somebody, and for the purposes of registering that sale, the sub-registrar might require you to submit certain kinds of information. Again, the sub-registrar can't possibly ask a person for the various sort of their health details and so forth. So this is where purpose limitation comes in, and as well as data minimization. So any information that you submit to the state has to conform to these principles of purpose limitation, data minimization, and storage limitation. That is, that the data is not stored by the state for longer than is necessary. There has to be a periodic review conducted by the state, and there has to be a general standard prescribed for how long this data will be stored within the state's domain. And of course, there are other principles which are also critical, which are also relevant even in relation to the Aarogya Setu app and other contact tracing applications of that kind, such as the aspect of consent, in the sense of when information can be collected from a person without such a person's consent. And we'll come to that again shortly. So a reading of the judgments in Puttaswamy 1 and in Puttaswamy 2 makes it clear that, as I said earlier, that we have a fundamental right to privacy, that this right can only be restricted by a validly enacted law, either by parliament or by the state legislatures. Thirdly, that this right to privacy includes not only a right to be left alone, but also a right to informational privacy, in the sense that any data that is collected by the state from an individual subscribes to certain core principles which are recognized universally. And fourthly, and I think this is again very important to our discussion today, which is that even a law made by the legislature, whether by parliament or by a state legislature, which restricts the right to privacy, must meet the requirements of legality, necessity, and proportionality. The Aadhaar judgment recognizes the Supreme Court's earlier verdict and another verdict of a constitution bench in the case of Modern Dental College and Research Center, where the court laid down this proportionality principle as having a fourfold requirement. Firstly, that any law which restricts a fundamental right must be in furtherance of a legitimate goal of the state. Secondly, that the measure chosen constitutes a suitable means of furthering that aim. Thirdly, that no other less intrusive or less restrictive measure was available to the state. And fourthly, that the measure chosen does not have a disproportionate impact on the right holder. That is, that there has to be a balancing that is done between the right and between the restriction that is brought about by the state and the aim for which that restriction has been brought about. So we can see on a reading of these two Puttaswamy judgments that these are the broad principles that govern how one tests a law that impinges on the right to privacy, and whether such a restriction is a constitutionally valid restriction or not. Now, when we look at the Aarogya Setu app, and I'll come to some of the problems in judicial review of these sort of technological solutions. But if we look at the Aarogya Setu app, it is broadly a contract tracing application, right? It uses both Bluetooth and GPS in order to trace people who have purportedly contracted COVID-19. And of course, it relies substantially on people disclosing the information to the state, as opposed to the state itself recognizing those who might have contracted the virus. And it is propelled, as I said, both by GPS and location tracking through GPS and through Bluetooth. Then the details that are uploaded onto the application are ordinarily maintained within the device itself, but there are certain specific circumstances under which those details get uploaded onto a central server which belongs to the government. And all of this is laid down to a certain extent in the privacy policy which has been devised by the application's makers. And strangely enough, in a protocol that has since been released by an empowered committee that has been set up under the Disaster Management Act. Now, the way the state is framing the sort of legal basis for this application is to effectively say that the application is a product of the measures that it has taken under the Disaster Management Act. Now, as we all know, once the lockdown was enforced, and in fact, the lockdown itself nationwide was enforced through the invocation of the Disaster Management Act. And under the statute, you have various sort of the ability to conceive and create various empowered committees. And it is one of these committees that has then been made responsible for the management of the Aarogya Setu App. This protocol that has since been released by the empowered committee basically now says that there are a few that some of these principles are in fact being conformed to according to it. But what we do see on a study of the protocol itself is that the protocol still doesn't actually conform to those principles of data minimization, purpose limitation, and data retention, which the judgments in Puttaswamy recognize as necessary components of the right to privacy. And there is a paper by the Internet Freedom Foundation, which was, I think, released yesterday, which analyzes the protocol quite deeply and points out how there are a number of problems with the protocol. For example, firstly, in terms of delegation of power to the empowered groups and how that delegation itself is questionable. How the protocol, in fact, doesn't even point out the consideration of alternative mechanisms to achieve the purpose for which this application has supposedly been released. As to, for example, why telecom operators are not being utilized, information from telecom operators is not being taken as opposed to actually going ahead with a contact tracing application of this kind. Thirdly, the use of a phrase, appropriate health responses. Basically, the protocol says that where appropriate health responses requires it, information can be translated from the device onto a server, and it can also be shared with other ministries. And I think this is deeply problematic. The moment you sort of get to this idea of sharing information across ministries for what the protocol describes as appropriate health responses. Now, appropriate health responses is an overbroad term, and it's not capable, I think, of clear and precise definition. And the moment you have sort of sharing of data from the device to the server and thereafter across ministries, then you really have the foundations for surveillance being laid there and then. So these are some of the general problems with the protocol. But the broader problem really is that the protocol doesn't have any legal backing. And this takes us back to the second principle that we can glean from the Puttaswamy judgments, which is that a restriction on the right to privacy can only be made by the state if that restriction is undergirded by a properly enacted legislation. Now, in India, not only do we not have a data protection law, of course, there's been a data protection bill that has been on the anvil for some time now, but this has not been placed before Parliament. Not only do we therefore not have a data protection law, we also do not have a parliamentary law expressly authorizing the use of a contact tracing application of this kind, which is then made mandatory. Now, had this contact tracing application been purely voluntary, then the questions that we might have had to ask would have been somewhat different. But given that it is being made mandatory, given that it's now being required for rail travel to the extent that it's been opened up, some states, for example, Haryana, made it mandatory for anybody who was who had arrived by air into the state after the lockdown was enforced in these recent air travels where we've been trying to bring people back into India. Then, as I already mentioned, the example of Noida, where it's been made mandatory for every person within Noida who owns a smartphone. Then we've also seen that it's been made mandatory for every public employee. It's been made mandatory by a number of different private companies for employees that they have engaged. So we can see how we've moved away from this sort of idea of using a contact tracing application on a purely voluntary basis to it being mandatory. And a paper by the MIT's Technology Review points out that India might potentially be the only democratic nation that has in fact made the use of a contact tracing application mandatory on its citizens. So given all of that, the fact that we do not have an express legislation authorizing an application of this kind is something that at the very outset renders this entire program unconstitutional. Now, of course, should such a law be made out? And here I think there are very interesting parallels with the Aadhaar program. Now, if all of you remember the Aadhaar program when it was originally conceived, even before it was christened as the Aadhaar program, we had a set of executive notifications that established the UIDAI. And it was under these notifications that biometric information was collected and a supposed unique identity was provided. It was also under these notifications that the UIDAI was tasked with the job of identifying people using biometric information and then providing people a unique identity number. And millions of people, in fact, had enrolled into these programs even before we had a statutory law for this purpose. It was really quite a staggering bureaucratic exercise that was being carried out. And I think it really ought to have perplexed our minds at the time that we didn't really have an underlying statute for this purpose. So I think today when we speak about Aarogya Setu, I think we must realize that this undermining of the rule of law in many ways is not something that is novel or new. It's something that happened even under the previous governmental regimes, where under the idea of supposedly achieving a greater good, massive administrative exercises were undertaken, which directly impinged on our sense of autonomy, on our sense of bodily integrity, and resultantly on our dignity and on our right to privacy. So therefore, there are a lot of parallels here that you can draw between Aadhaar and Aarogya Setu. Also remember that when ultimately the Aadhaar Act was enacted, it was introduced as a money bill. You had a scenario where Lok Sabha passed the act, and then because it was introduced as a money bill, it was sent to the Rajya Sabha merely to get the Rajya Sabha's recommendations. The Rajya Sabha thereafter made a number of recommendations, and all of this was completely disregarded. And you had the Supreme Court upholding this act being enacted as a money bill. So it's the sort of thing that I think is productive of great public mischief. And you might well have a case tomorrow where the Aarogya Setu application, because money goes into it from the consolidated funds, might well be be given some sort of legislative force through a money bill. And I don't know if that's something that might happen, but it's in Aadhaar, at least I think in the beginning you had a veneer and a facade of it being voluntary, which of course dissipated with time. But in the case of Aarogya Setu, it's dissipated even quicker. So therefore, there are lots of parallels that we can draw between the Aadhaar program and the Aarogya Setu program. And I'll just say a few words and then conclude and open it up for questions. As I said, there are still a few important takeaways from the Aadhaar judgment. We know there exists a right to privacy. We know that right can only be restricted by law and by subscribing to principles of legality, necessity, and proportionality. We also know that the creation of a surveillance state, that is, that the providing a mechanism to the state through the information that it's collected to profile a person, is on its own unconstitutional. Therefore, given all of this, will the Aarogya Setu application be something which upsets the fundamental rights chapter, and is it something that is plausibly unconstitutional? I would argue that it absolutely is. But I think there's one other aspect, which is the aspect of efficacy. Now, we've already seen that there are a number of reports on how contact tracing applications aren't at all efficacious. They don't actually work. They don't perform the job that they're supposed to be performing. So I think that's where you run into this possibility of an app such as this turning into a Trojan horse for a surveillance device. And if you look at the Aadhaar judgment, you'll see that the court actually doesn't engage with this sort of a deep analysis on the aspect of efficacy at all. There's no sort of discussion on how or whether Aadhaar was in fact an efficacious program, on whether alternatives that were suggested by the petitioners in that case, such as smart cards and social audits that were used in Chhattisgarh, for example, the PDS system in Tamil Nadu where smart cards and POS machines were used. All of this was presented to the court, but the court didn't engage with these alternatives at all. So would a challenge to the Aarogya Setu application therefore succeed? It would depend on the court engaging in an analysis which is vastly different from the kind of analysis that it engaged in the Aadhaar case. There's one other aspect, the aspect of function creep, and I think I'll conclude the talk with this. Now, when you don't have a law and when you don't have a data protection legislation, it's impossible in many ways to avoid the kind of function creep that we've seen with Aadhaar also applying to Aarogya Setu. As I said earlier, India is apparently the only democratic nation that is compelling the use of a contact tracing application. But we could also have a scenario where we have all kinds of exclusion that happens as a result of this. Now, if for example, welfare is made conditional on the use of the app, then we can see that the app will have a sort of function creep which will tend to violate not only the right to privacy, but would have an attendant impact on a number of other rights, such as the right to health itself, or the right to access social security measures and so forth. The final problem with all of this, I think, really is the aspect of illegally collected evidence. And I think this is important for all of us to recognize. Now, in India, the Evidence Act doesn't actually say that when evidence is collected illegally by the state or by a person, that it cannot, in fact, be inadmissible in a court of law. The Constitution doesn't explicitly say this, nor does the Evidence Act explicitly say this. Of course, there are judgments such as the judgment in Selvi versus State of Karnataka, which speaks about how unconstitutionally obtained evidence, not merely illegally obtained evidence, but unconstitutionally obtained evidence might not be admissible in a court of law. But there's a vast amount of confusion on this. But by and large, courts and high courts across the country tend to recognize the general principle that it doesn't matter how evidence is collected. So you could well have a scenario where vast amounts of data are collected by this Aarogya Setu application and it's distributed across ministries and so forth. Now, this collection of this information might well be illegal and unconstitutional, but it could still potentially be used against people in various different capacities. It could be used in criminal prosecution, it could be used in civil proceedings, it could be used in matrimonial proceedings. We have all kinds of proceedings in which it can be used. So I would therefore say that the idea of there no being law tends to have a sort of spiraling impact, which then leads to all kinds of rights violations. It's not merely a violation of our right to privacy today, but it also leads to a violation of various different rights, a right against self-incrimination, a right to personal liberty, a right to free speech. And the moment it sort of has this sort of instrumental impact on all these other various rights, it then tends to have a deep impact and impinges really in many ways on the very idea of India being a democratic nation where each of us governs ourselves and where the sovereignty ultimately rests with the people. I'll be happy to answer any questions that you might have either on the topic itself or on any attendance subjects that you might have questions on. Thank you.
Thank you, Suhrith. Wonderfully elaborate in terms of how you traced out the entire constitutional judgments on this issue. From there, the principles that emerged to the data protection bill and not having an act until the Aarogya Setu. So yeah, I think a lot of people, even if there are non-lawyers listening in, they would be greatly benefited by your analysis. I have a couple of questions before I open it for questions by the audience. And for the benefit of clarity, I'd already shared some of these with Suhrith earlier. And some of it he has already answered on the question of the mandatory nature, etc. But I have two specific questions that I'd like your views on. The first is that the protocol requires adherence to all of these following things. First, it requires a hard anonymization before data sharing, mandatory deletion of data. It's a 180 days period that has been mentioned in the protocol. Then there's the standards of necessity and proportionality have been mentioned in the protocol, and collection limitation and use specification along with penalties for breach. So if the protocol is creating all sorts of controversies, do you think that the critics are being slightly unfair, considering that a number of the principles have actually been incorporated within the protocol itself? Now, whether they'll be enforced or not, of course, is a second question. But primarily that these standards have been mentioned in the protocol. Do you think that kind of ameliorates the issue somewhat?
I don't think so at all, Agnidipto, for various reasons. One reason was spelled out by Justice Sri Krishna yesterday, which is that what is the force of law that this protocol really has? I mean, why should we take this protocol seriously at all? Because it's really, as he said, like an intergovernmental communication. Now, if it's a purely intergovernmental communication, it doesn't have any force of law at all. And the second issue with the protocol, and I think this is something which very many experts would be sort of dealing with over the course of the coming days, I'm sure, and I referred during the course of the talk to sort of a draft paper that's been and an analysis of the protocol that's been released by the Internet Freedom Foundation. And it points out a number of deficiencies in the protocol itself in terms of these various things that you mentioned, even in terms of the collection and processing of response data, in terms of the storage of the data. Because as I said during the talk, I mean, if you have a situation where for, in a sense where data can be shared for appropriate health responses, and that's the term that the protocol uses, then it's incredibly vague. I mean, it really defeats the entire purpose of having a set of principles which would minimize collection of data, which would minimize the storage capacity of the data, and which would also minimize the purpose for which the data is collected. And in fact, the protocol doesn't explicitly spell out what the purpose of collecting this information is at all. I don't think, in fact, purpose limitation to me appears to be wholly absent from the protocol, because it uses these incredibly broad terms. Now, a term such as appropriate health responses could really mean anything. Now, and that I think is where it's deeply troubling in many ways. If it doesn't have to be restricted to COVID-19, it can be restricted to other kinds of health responses, for example. And it also says that it will be sort of, I mean, in terms of storage limitation, it doesn't really say much, except that at the end of 6 months, they might review this protocol again. So I think that an adherence to these principles in many ways is really absent from the protocol, apart from the fact that this protocol, to my mind, is of really no value. Right. It's of really no value, because who are we going to go and hold up this protocol and say that, look, this protocol is being violated? Now, if there's no law, of what real force is this protocol? It's ultimately, in a country that's governed by a constitution where the rule of law is considered as sacrosanct and paramount, when a fundamental right is being restricted, we need a statute. And, you've seen the benefits of this to a certain extent with the Aadhaar Act, right? We know that the Aadhaar Act is not only imperfect, but there are a number of flaws with it, at least as many critics would point out. But at least in laying out a number of things, it allows us to engage with it in terms of what are its potential frailties. Now, if you don't have an act, you can't even point out what are the deficiencies, because it's completely deficient. There's not a single thing that it conforms to. So where's the question of really saying that there are one or two of these principles that are absent? In my book, every principle is absent because there's no law. And that's where everything really starts from. Once we have a law, and the law points out clearly that this is the purpose for which information is being sought for and retained, this is the sort of storage limitation that would accrue to the data, and on what in what circumstances consent can be revoked, in what circumstances people can ask for data to be returned, and so forth. Unless an act clearly spells out these things, we are sort of really left grappling in thin air.
Absolutely. My next question is kind of taking off from what you mentioned, that we don't really have data protection framework, though there have been two bills and both bills have been quite controversial. The question of there not being a data protection framework, and yet there have been a number of acts which we've seen, a number of executive orders also passed, which would clearly have fallen within the realm of data protection, which begins with the Aadhaar but doesn't end there. There's the DNA technology bill about which you have yourself written. There's now the Aarogya Setu App. So there's been a number of governmental measures taken in the interim while the data protection bill has been pending. Considering that in the Puthuswamy judgments, public health was considered to be a clear exception. Even the data protection bill mentions health as a ground for exception, creating exceptions to the privacy regime as such. Would you say that there is, can we rely on the judiciary to deliver us from this kind of a situation, considering the way that, it responded in case of the Aadhaar?
Yeah, I mean, we should lose confidence completely, obviously. And I think there have been a number of cases where the courts have not responded to challenges made to technological solutions in the way in which we might have expected the court to do so. But, and I've said this in a different talk that I'd given, I think this is, in many ways, the idea where, I mean, the sort of interlinking between tech and technology and judicial review is a very interesting sort of realm. It's, I think, a big project. It might well be the defining project of our times, because we're going to have a world in which there are more and more cases where technological solutions are prescribed for different kinds of problems. We're going to live in a world where artificial intelligence is being used to address various different concerns of ours. And ultimately, the use of all of this technology is going to have a bearing in some way or the other on the way in which we lead our lives. From the freedoms that we enjoy, from the rights, various rights that the Constitution guarantees, to various different values that the Constitution espouses. So this is, to me, an issue that we need to give sort of really deep attention to. It's not something that we should take lightly. But it also requires us and requires the court to reconsider its entire way in which it's approached judicial review until now. Until now, we have had a situation where courts, by and large, look at factual analysis as somehow anathema to judicial review. And I'm talking about judicial review in the public law realm, not in the private law realm. The history of administrative law has sort of been developed with this idea that somehow appellate courts would not be the kind of forums where factual disputes are adjudicated upon. But in India, we have a peculiar situation, unlike, say, in the UK, where issues of administrative law would first be sort of ruled upon by, let's say, a tribunal, which looks at the various rival versions of the facts and comes to a factual determination. The higher appellate forums then have that basic sort of factual decision that's already taken, and then they can just decide on whether a statute has been violated, or in the case of the Human Rights Act, which sort of the Britain came late to, has been violated, and so forth. In India, when we challenge an action of the executive, for example, as violating the Constitution, or even a piece of legislation which offers a technological solution as violating the Constitution, we are either arguing directly before the High Court first, or directly before the Supreme Court under Article 32. So these constitutional courts are essentially serving as courts of first resort.
Yeah.
The standards that they have devised for judicial review, the standards of proportionality, for example, are very, very fact-intensive standards, right? These are not standards that can be loosely applied without deeply engaging with facts. So, for example, where you have, let's say, the Aarogya Setu application ultimately receives some sort of legislative sanction, and that law is challenged in the Supreme Court. You might have petitioners going before the court pointing out that there are these XYZ ways in which the same purpose can be achieved. And these are less intrusive on privacy.
Correct.
You might have petitioners pointing out, based on evidence that they supply through affidavits, let's say they have technical experts who file affidavits, to point out that the code, and this is assuming that the code is opened up, is somehow deficient, and it doesn't in fact achieve or relate to the purpose for which the app has been created. I'm just saying, hypothetically, this argument is made. This will require the court to engage with all of this, right? It doesn't, at the moment, the culture of judicial review that exists in India doesn't actually allow the courts to engage with these kind of questions. It sort of will be, its natural response would be to say that these are things that we somehow, sitting as judges, cannot look into. It's for the state to decide. And ultimately, the result of all of this is, because we have a system where constitutional actions are generally presumed to be constitutional, or parliamentary acts are presumed to be constitutional, we'll have a system where the court ends up believing the version of facts that the government supplies. So I think we need to sort of deeply engage with all of this and have the courts and bring about a change of culture, really, in terms of challenges that might be made to solutions that are technological in nature, where courts will have to alter their mechanism of collecting evidence quite substantially. Whether this is in the form of the courts creating independent commissions, which might then look at the various rival contentions that are made and thereafter take a call on it, or what that is something that we all have to, I think about more deeply. But it's certainly the present system, the way in which judicial review works presently. I think the odds are staked heavily against challenge made under the in sort of constitutional terms to technological solutions.
Right. So at this point, I think we can start taking the questions from the audience. If they will appear one by one on the.
Okay, I haven't seen any of these. Sorry, if you can just sort of take me through them, I can.
Yeah, sure. Ayushi, if you could just play it on the screen.
Yeah, I have it on the screen now.
Yeah. So Vaishak Shaji is asking, what immediate remedy available to a citizen who exercises informed consent and wishes not to use the Aarogya Setu app, contrary to the mandate by the state? What is the remedy available in case somebody doesn't want to use the app?
Yeah, so the only real remedy available is to challenge this app and challenge this compulsion in a court of law, right? I mean, ultimately, even an executive order can carry the force of sanctions. So if you're going to, let's assume you're not allowed to travel without the app and without showing the app to the, let's say, whoever is the authority that's put in charge of looking into this, then the only real option is to challenge it in a court of law.
Right.
Now, otherwise you won't be able to travel. Let's say air travel, they make Aarogya Setu mandatory. Then how do you travel by air without, in fact, downloading the application? So I think that ultimately a challenge has to be mounted. It's already been done before the Kerala High Court. The High Court has so far refused to grant a stay, but I think it's still hearing the case. It's asked for the government to respond. And look, the other big problem with it is also a question of smartphone penetration in India. Now, the general consensus, I believe, is that for these kind of contact tracing applications to be efficacious and for them to work, you need at least half the population to, in fact, have the application, right?
Correct.
Now, I don't even think you have that kind of smartphone penetration in India, let alone have every smartphone have them downloaded with the application. So I don't know what kind of efficacy is going to, in fact, emanate out of the application itself. So to answer this question briefly, though, the only real remedy available is to approach a court of law.
Court of law. Radha Murthy is asking, how different is the Aarogya Setu app from the contact tracing apps being used elsewhere, such as in Taiwan, South Korea, England, and Singapore? In fact, there are also China and several other countries which are using a similar platform.
Yeah. So I believe vastly different in many senses in terms of the kind of technology that's being used. There is, I don't know if I can, if there's some way for me to share this table, but there's a table that the MIT Technology Review again put out, and I can share it subsequently, which points out how each of these applications are different. And this is the same paper that also points out that India might be the only democratic nation that in fact has made it mandatory. But also in terms of the technology itself that is used, not too many countries are using sort of GPS technology. I think that's one sense in which it's vastly different. Some apps have identified a person's contact by tracking the phone's movements, like in India, is by using GPS or triangulation. There are others that have used Bluetooth and used proximity tracking. Some other applications have relied on the technology that's supplied by Google and Apple. That is, it's used iOS and Android phones to sort of relate to each other over Bluetooth. So each of them has been quite different in the way in which they've approached it. But what the table points out is that the Indian application is the one that's sort of amongst the least compliant with the various data protection requirements. Of course, China, we have no sort of information that's available, for example, to the public. We don't know what the application actually comprises. There are other countries as well where there's very little information that's been made public. But we've seen, if I can just point out a couple of examples where these applications have run into trouble. An application which has been devised in the UK, a parliamentary committee has already had a look at it and said that this cannot work given the current laws that are in force. Similarly, the Israeli application, you had a challenge to it, and the Constitutional Court there returned it by pointing out that to effectuate the use of an application of this kind would require a legislation.
Right. Yeah. Anyan Vengam is asking that the Aadhaar judgment concluded that private companies are not allowed to use data collected through the Aadhaar portal, and now government through some ordinance is allowing private companies to use. So the idea, I think, to put it in different words, is essentially how the Aadhaar judgment, the effect of the judgment, was undone by amendments later. Again, something that you've written about. And do you think that there's a possibility of a similar thing happening, even the function creep that you were talking about, being effectuated despite the protocol, purportedly restricting its application only to the COVID-19 situation?
Yeah. So, I mean, I think what the question is specifically referring to is the striking down of Section 57 of the Aadhaar Act and the subsequent law that was introduced, which then thereafter continued to allow private entities by some sort of backdoor entry to use Aadhaar as a means of verification. Now, this is, I think, a problem, certainly in terms of rule of law considerations, because if you have a Supreme Court judgment, now one point that I want to make is the court does deal with give judgments in terms of whether a particular action violates fundamental rights or not, right? And then let's say it strikes down a program. Now, there is no specific bar on the legislature from bringing about another legislation, so long as it removes the basis on which the original law was struck down. The problem here is that the subsequent law that was introduced, it confirmed, in fact, to certain things that the Supreme Court said needed to be done. For example, in terms of rights of children, etc., which the Supreme Court enjoined Parliament to bring into the Aadhaar Act, it did bring about those amendments. But the problem is in terms of the use by private entities, it didn't actually remove the underlying basis on which that original Section 57 was struck down as unconstitutional. So, which is why this new law was once again challenged in the Supreme Court. That challenge is, I think, still pending. I mean, it is still pending. So, hopefully, the court will, view this as a sort of affront to its integrity, to its sense of, to the very sense of rule of law, and strike it down.
Okay, this is a very interesting question, which I think a lot of people, especially non-lawyers, are confounded with. Shreyas Talin is asking that all the talk about there not being a legal basis loses its force in unprecedented times such as this. I wonder if data indeed is abused, can one approach courts under, of course, the writ jurisdiction question you've already answered. But the first part of this query, something that a lot of people seem to be grappling with, is that why are we not considering the fact that these are unprecedented circumstances and therefore certain latitude needs to be given to the government under these circumstances?
Yeah. So I'd written a joint article on this in terms of with Gautam Bhatia and Appar Gupta in the Hindu on why precisely in these sort of unprecedented times we need to value our freedoms deeply. Because we've seen, I mean, the history of not just India, but the history of democratic nations across the world, that these unprecedented times are often used to wither away and strike at freedom. And thereafter, those circumstances tend to become permanent in nature. Civil liberties tend to virtually be permanently effaced by invoking those very measures that stood during these unprecedented times. But let's be also clear on a couple of things here. One, we've not had a formal declaration of emergency, right? What we've had is an invocation of the disaster management. We've not had an invocation of an emergency. Now, we of course know, I mean, during ADM Jabalpur, the famous habeas corpus case, you had the Supreme Court possibly in its nadir, holding that in an emergency, rights under Article 21 stand suspended. But we've since had a plethora of cases, which was then thereafter made explicit by a plurality of opinions in the first Puttaswamy case, that this ruling in the habeas corpus case is no longer good law, that even in an emergency, our rights and freedoms cannot be suspended. Now, of course, during unprecedented times, the balancing of our rights with those sort of legitimate state interests would require a sort of shift in terms of giving slightly greater leeway to the state on what it could do. Now, it would be completely illegal or unconstitutional to even have a contact tracing application of any kind during regular times. Now, we have a pandemic, which is why a contact tracing application might be potentially plausible. But that doesn't mean that that application that is made is simply sort of written off in terms of us giving complete sort of plenary power to the state executive to do whatever it pleases in terms of dealing with the situation. Now, it could come up with all kinds of measures, right? What if it restricts movement entirely and says that, no person, let's say these are unprecedented times, you can't even step out to get groceries. Do we then still say that there's no need for any fundamental rights? We're already seeing this problem in terms of the issue that the migrants are facing, right? In terms of interstate travel. Can we say that because these are unprecedented times, migrants shouldn't be allowed to go back to their homes? We can't say that, right? So I don't think you can really say that unprecedented times call for a complete destruction of our freedoms. It doesn't call for that. We still live in a system which respects the rule of law. The Constitution already provides a clear delineation of how one deals with times such as this. It gives the state the power to make restrictions which are proportionate in nature. So if a restriction is made on our freedoms in order to deal with this pandemic, which is proportionate in nature, none of us will really have a problem with it. We'll, of course, even welcome it because the state is then doing something which is completely in consonance with its constitutional role and responsibilities.
Right. Aniket Singh asks, legally, how would such an app be promoted by the state? With what kind of limits and exemptions in order to escape liability for unauthorized access to third parties? So if you were basically looking at this from the other angle, that how would you have framed this law in such a way that the third parties' access to data does not create a liability for the state?
Yeah, so the first thing that you need is legislation. Now, if parliamentary law is difficult at this time, given the urgency and the sort of unprecedented situation that the previous question spoke about, then perhaps an ordinance. That's the first thing that you need. You need a specific law, a piece of legislation that would, look to give the undergirding basis for an application of this kind, which impinges on a person's privacy. I think that it's difficult to frame even a law of that kind today without there also being a data protection law. Now, this is something that we only have ourselves to blame for, right? Not having a data protection law today.
Correct.
But assuming that because during the time of the pandemic, it's difficult now to legislate a data protection law, then you still need to take into account all those various principles that are critical to a data protection law, which, as I mentioned during the talk, was covered in the Swami judgments, and especially even in the Aadhaar judgment. These principles of data minimization, uh, purpose limitation, storage limitation, etc., consent, etc.
Yeah.
And then write all of that into the law to make it very clear what the purpose is, what the storage limitation would be, what sort of data will be collected, provide people, for example, you have the right to be forgotten, right, which is recognized now even in India to a certain extent. There's at least one high court has recognized the right to be forgotten.
Yeah.
So these are things that need to be considered and taken into account before a law is made. And most important is that, I mean, I'm far from an expert on these issues, but the code needs to be opened up, right? It needs to be made open source so that people can study it, so that people can look into it and, in fact, figure out whether the application does the job that it claims to do or not. Now, unless the code is opened up, how do you know that? That's one other thing that I think absolutely has to be done. Now, there is, again, I had made a mention of this in another talk that I'd given. There's an interesting speech of Lord Sales of the UK Supreme Court, which is available on the UK Supreme Court's website, where he speaks about, again, requiring this sort of paradigm shift in terms of our entire approach to technological solutions. But he also speaks about how you possibly need an independent body which will examine the code, sort of an algorithm commission almost, which will be independent of all of these bodies. It might even be a parliamentary committee, which we have in India, in terms of our pre-legislative scrutiny. But have committees which will comprise not only parliamentarians, not only lawyers, but also people who are well versed in technology, in science, and ethicists. Have people who are able to look at these things from various different perspectives and then tailor a solution. It's not that these things can't be done even in a extraordinary situation such as this. If we had these committees in place, we might be able to respond to these challenges better. So it's important, I think, that we strengthen our institutions, every institution that we have. It's important that we place faith once again in these institutions, strengthen them so that we can really respond effectively to situations such as this.
I think that's a very interesting point that you make, considering that in the Aarogya Setu's case, for example, the source code is not accessible. So in that sense also, okay. Varun Kannan has a question, where he says, can a hypothetical Aarogya Setu law legitimize collection of data that took place before such a law was enacted? Similar argument was made with respect to collection of Aadhaar data before 2016.
Yeah, he virtually answers his own question, really, because I don't think it can or it should be allowed to do so. But this argument was made quite vehemently in the Aadhaar case, and it didn't find favor. The dissenting judgment, I think, quite clearly points out that if something doesn't have the force of law, you can't retrospectively validate the collection of data, because the very collection of data was made without those principles being taken into account. So you can't retrospectively constitutionalize what is really an illegitimate collection of data. But unfortunately, that didn't quite find favor with the majority's judgment. But it's something that needs to be re-argued if and when a fresh challenge comes up.
And in fact, I think the dissenting opinion of Justice Chandrachud also mentioned deletion of data, which after striking down 57, which again none of the other judges in the majority seem to refer to. So, okay. I think these are not particularly relevant. Yeah. So Prashant Shukla has a question in which he says, is it possible for the government to use the data for the purpose of COVID-19 research and experiment, given that its intended purpose is contact tracing? I think that exception has been made in the Aarogya Setu protocol, at least. that
Yeah.
research. Yeah.
Yeah, the protocol makes that extension, but I think again that's the problem, right? I mean, if we don't have a law, I'm sorry to be sort of circling back to this point time and again, but unless you have a law which specifically limits the purpose for which something is collected, how can we? We're really talking about a lot of these things and sort of the thin air really, because if it's collected specifically for the purposes of contact tracing, then ideally it should not be used for research and experimentation, right? Because it would go beyond the purpose limitation for which the application is built. So that's the short answer to Prashant's question. But this really again reiterates, I think, in many ways and reinforces the need for a statute. Without that, not only would we be speaking in thin air, we would really be giving vast swaths of information to the state without any constitutional protection at all.
Absolutely. Rajat Bector's question is that surveillance systems didn't really work in China. Maybe we could move towards decentralized apps like proposed Google Apple systems, which uses, I think you were mentioning this in the course of another answer, which uses Bluetooth signals rather than GPS. I think this the Aarogya Setu app does both. So this is the most efficacious.
I saw this interview, fascinating interview with a fascinating profile really of the Kerala Health Minister today in the Guardian. Kerala, as we all know, I mean, as our experience now has shown us, has managed to sort of limit the contraction of the virus quite substantially, and they've done a job which is possibly far better than many other foreign countries and many other Western nations. And we've seen, as Rajat points out, that these kinds of contact tracing surveillance might not necessarily work. And in fact, I think there's substantial evidence now to point out that they don't actually really do the job for which they're intended, which then means that you have to look at other kinds of surveillance systems, which don't necessarily involve contact tracing. And a more sort of personalized surveillance, where information of this kind is not collected by the state, I think works far better in terms of actually sort of limiting the contraction of the virus itself. Right. And do we move to decentralized apps? Yeah, I suppose that most other countries, but the other thing is, you don't want this to be coerced, right? Like ultimately any technological solution. And the moment you have these contact tracing applications that become objects of coercion and become mandatory, that I think opens up an entire other stream of problems. So I think I in fact think that solutions are available, even sort of almost non-technological solutions are available.
Yeah.
Even within the examples that are available to us from within India, which have shown how the virus can be contracted by sort of, and it's also sort of important for us to be, I think, really speaking about what else the state needs to do in limiting the spread of the virus, apart from these sort of these kinds of solutions. I mean, we clearly have to also think about investing more in public health, even in terms of these stimulus programs that have now been announced, in terms of what is actually going towards the purchase of ventilators, purchases of other kinds of personal protective equipments to doctors, nurses, other frontline workers, etc. So what are we doing to sort of really protect them? And those are solutions that can and will contribute towards the limiting of the spread of the virus as much as, and far more, I think, than any technological solution of this kind might.
Anand Krishnan asks, do you think the Aarogya Setu app could be used by other enterprises, seeing its mandatory nature, for example, by restaurants to look into the health status of their customers? I think if I could just add another bit to his question, that is, it's not just a question of whether private players are going to be able to use it on some future date. But I think another question that has emerged another concern that has been voiced by many in the backdrop of the pandemic relates to how segregation might come back into practice, or in fact, become mainstream. because of these kind of apps. Now it'll be on a basis of health maybe instead of other bases as we've seen in history.
Yeah, and I think there'll still be an incredible class and therefore caste component to it as well. It's an interesting question in terms of whether private enterprises can start. If, for example, as he says, if you were to want to enter a restaurant, and then they don't allow you to enter without you showing your phone and showing them the app, or ensuring that the app is uploaded onto your phone. And you've already had messages, for example, come from not only private establishments, you've had schools send messages to parents saying that, look, when schools ultimately reopen, that we recommend. Right now, the language is still we recommend that the application be downloaded. So this is certainly it's not something that we can't consider as potentially plausible. It's certainly plausible, but it would again be unconstitutional because I don't think without a law which allows private entities or allows people to make this a precondition for the availment of services, something like this can be done. And even if such a law exists, such a law I think would strike at a number of different rights. Because this is again a problem which we saw with Aadhaar as well, right? This entire argument was made about this sort of unconstitutional condition, in the sense that you can't waive your fundamental rights, and there are various other fundamental rights that are linked to this. So, for example, as I mentioned during either to an earlier question or during the talk, in terms of your ability to avail services, your ability to avail welfare, if all of that is made conditional on an application of this kind, that would, I think, constitute an unconstitutional condition.
Absolutely. Srivastava is asking, sir, even keeping pandemic and the necessity test in mind, does it qualify as the least restrictive test? And secondly, I think more importantly, what are the remedies available in case of data breach or leaks similar to Aadhaar, considering that there is a penalty requirement which is mentioned in the protocol? So again, the protocol itself being in question.
Yeah, on the first question, there are a number of other options that are available. As I said, so if a person is mounting a challenge to the Aarogya Setu application, what are the arguments that they'll make? The first argument that they'll make, which we've repeated again and again, possibly ad nauseum, is that there is no law.
Yeah.
The second argument that will be made is that even assuming, let's say that there is no need for a law, which cannot be the case at all, that in any event, there's a lack of efficacy here. That is, that this application doesn't in fact do the work that it's meant to do. The third, which they'll make and which she mentions, is that this is not the least restrictive measure that is available for the object. If the object is to stop the contraction of the virus and the spread of the virus, there are other alternatives available, which is why I mentioned the example of the interview with the Kerala Minister for Health, where she points out the ways in which Kerala has been able to quell the virus, which then therefore means that there are potentially non-technological solutions available. Now, of course, we should also not lose track of the fact that Kerala also had an app of its own, which ran into its own set of problems with the Kerala High Court intervening. But of course, none of that was made mandatory in the manner in which the Aarogya Setu app has been made mandatory, nor was it really a sort of, almost key or milestone sort of mechanism in their fight against the virus. So, which means that there are other less restrictive measures that are available. On the remedies, well, the remedies at this stage will have to be constitutional in nature, right? If you had a statute, you would then have statutory remedies that are prescribed. But we neither have a statute for Aarogya Setu, nor do we have a data protection law, which means that there is no privacy law today. And in the absence of a privacy law, the only remedy which you mentioned earlier is to file a writ petition either under 226 or 30.
Right. So I think that brings us more or less to the end of the questions. There's a lot of repetitive questions which I'm not going into. I have one last question which I will ask at this point. So a number of scholars such as Harari, etc., have mentioned how a number of thinkers such as Harari. Can you hear me?
Yeah.
So a number of thinkers such as Harari have written articles and mentioned that the pandemic might be, that springboard from which the surveillance state might emerge and could become the new normal for the future. Do you see the the situation generally speaking, and in particular the app as being that springboard?
Well, the situation generally speaking, certainly yes. You've already seen across the world, in Hungary, for example, where you've had existing democratically appointed leaders try and assume a role that goes far beyond their democratic sanction. So this is a fear that we all need to be alive to, in the sense that which is why we need to speak up, which is why we need to kind of try and engage with the state in various different ways that we can. So you've had this prospect of the dilution of the labor laws, for example, which many state governments have proposed. But that would effectively bring to an end, if those laws are diluted in the manner in which it's been suggested. That would then effectively bring to an end a number of fundamental rights that are guaranteed by the Constitution, right? Not least the right against forced labor and the rights to dignity, etc. So if you have measures such as that, which are considered as critical solutions to dealing with the pandemic, then you certainly, I think, not only have a potential surveillance state on the anvil in terms of what you mentioned, Anirudh, in terms of an extension of the Aarogya Setu app itself, but you have all other kinds of coercive mechanisms that are then put in place. You've had the UP government suggest criminal prosecution for not having the application. So it's just it's sort of almost a sliding slope where you sort of move from the notion of a rule of law that is built on the basis of constitutional principles to a slow withering and slow and almost drastic withering of those principles, because we want to believe that this pandemic somehow calls for extraordinary measures that are beyond the contours of the Constitution. And that is where I think the problem really begins.
Thank you very much, Suhrith, for a session that was that not only touched on the subject it was supposed to be on, but went far, far beyond that. We spoke of democracy, of constitutional governance, and so many other issues. Thank you so much for your time, which, as we've seen, we've already run out of. And there are subtle signals being shown on screen telling us that enough is enough. Let's wrap it up. So thank you once again, Suhrith, for a great session. And I am sure that all the audience that were present have greatly benefited and become more aware of generally what to do with their Bluetooths. Thank you so much.
Thank you. My pleasure.